Today's webinar on biosimilars and the BPCIA. This is the next in our series of Kenobi Martin's webinars. We thank you for joining us today. My name is Mike Fuller. I'm a partner here at Kenobi Martin's, and I'll be moderating the panel that I'm going to introduce in a second. But I first want to go over a few housekeeping items for you. First off, we do offer CLE credit for today's talk. If you didn't fill out your bar information when you signed up for the webinar, you see the attached slide. Please email Shanika Shaw here at Kenobi Martin's, and she will make sure that you get your proper CLE credit. I also wanted to point out that the slides and video stream of today's presentation is going to be available on our website after the talk today. And you'll be getting an email and a link following the presentation, so you have access to all of that. You're also welcome to, of course, share that with any colleagues that weren't able to make today's webinar. Also, we ask that if you have questions for us, we appreciate it. If you look on the bottom right corner of your screen, you'll see a chat box. That's a chat directly to us. It does not go out to the other members of today's webinar. And if you have a question, please just fill out the chat and send it to us, and we're going to save room for questions at the end of today's webinar. Also, we ask that at the end of the webinar, you'll be getting a survey from us. We sure appreciate your feedback and input on future topics, on what we can do to improve the webinars. We're going to be continuing to do these every couple months because they've been so popular for us. And so any suggestions you have, we sure would appreciate any input from you so that we can make them as terrific as possible. So I want to introduce the panelists first today. So Sheila Swaroop will be coming in a minute. She's a litigation partner here at Kenobi Martin's that focuses on pharmaceutical and medical device litigation. Next on the panel is Carol Pitzel-Cruz. Carol is also a litigation partner here at Kenobi Martin's, and she focuses on pharmaceutical and Hatch-Waxman litigation. And third on the list is Eli Lutz. Eli is a molecular biologist and a partner that's in the client practice area. So he focuses on patent prosecution and strategies for pharmaceutical products and medical device products. So the way we've set up the panel discussion today is first Sheila's going to come give an introduction to the U.S. biosimilars and the BPCIA. And then Carol and Eli are going to talk about preparing for pre-litigation exchanges for the reference product sponsor. And Eli is going to talk about post-AIA portfolio strategies for the reference product sponsor. Now, once we talk about strategies for the reference product sponsor, we're going to switch over and talk about how the biosimilar applicant does the same thing. So how does the biosimilar applicant prepare for a pre-litigation exchange, and what are some of the post-AIA strategies that the biosimilar applicant can take in challenging patents at the USPTO? And then finally, Carol's going to talk about enforcement considerations from the reference product sponsor and also the biosimilar applicant. So I'm going to go ahead and ask the panelists to take seats here where I am, and we'll get started. Thank you very much.
Hello, everyone. My name is Sheila Swaroop, and as Mike mentioned, we'll be starting today with a brief overview of the U.S. statute governing biosimilars, and also a brief summary of the pre-litigation patent exchange that is contemplated by the statute. So the regulatory pathway that governs U.S. biosimilars is called the Biologics Price Competition and Innovation Act. It's often referred to as the BPCIA. It was enacted in 2010, and it creates an abbreviated approval pathway for biological products that are demonstrated to either be biosimilar to or interchangeable with a previously approved FDA product. The statute and some FDA draft guidance documents give some specific definitions as to what constitutes a biological product, and we have that on the next slide here. And as you can see, the definition is quite broad. There are two things I wanted to point out, which is that the FDA guidance document has a specific definition as to what constitutes a protein that would be considered to be a biological product under the statute, and that is any alpha amino acid polymer that is greater than 40 amino acids in size. In addition to that definition of protein, there's also an exception carved out for chemically synthesized polypeptides, and with respect to those would not be considered biological products that are governed by the statute. The statute also has two concepts of products that would be contemplated to be approved under the statute. So there are biosimilar products and interchangeable products. A biosimilar product would be a product that is highly similar to a previously approved biological product in that there's no clinically meaningful differences in terms of safety, purity, and potency. An interchangeable product has to be not only biosimilar, but also has to have some additional showings as well. So in addition to demonstrating biosimilarity, an interchangeable product must also be expected to produce the same clinical result as a reference product sponsor in any given patient. And also, if the product is going to be administered on multiple occasions, then there needs to be some demonstration that the risk of safety or diminished efficacy of switching between the interchangeable product and the reference product is no different than the risk of simply just using the reference product sponsor in the multiple dosing situation. So what we wanted to talk about in a little bit more detail today is the pre-litigation exchange that's contemplated by the statute. And what the statute contemplates is essentially two entities that participate in this process. On the one hand, you have the reference product sponsor, or RPS, which is the holder of the approved biological license application. And on the other hand, you have the biosimilar applicant, which is the entity that is seeking to take advantage of the abbreviated approval pathway. And the statute contemplates a very detailed exchange of information between those two parties, and also creates a jurisdiction for the submission of the biosimilar application to be considered to be an active patent infringement, so that the parties can litigate these issues prior to any commercial marketing or launch of the biosimilar product. So with regard to the pre-litigation patent exchange, one question that often comes up is, when would this exchange take place? And there are certain defined periods of exclusivity within the statute. And as you can see from this next slide, we have a timeline which charts out these periods of exclusivity. So as you can see on the left at year 0, that is the year when the reference product is first licensed. And within that 4-year period is what's referred to as the period of data exclusivity. So during that 4-year period, no biosimilar applications can be filed. After the expiration of that 4-year period, there then enters a period of what's referred to as market exclusivity. And during that period, a biosimilar applicant can submit an application to the FDA for approval. And the thought is that during that 8-year period is when the pre-litigation exchange under the BPCIA would take place, and the parties would attempt to resolve patent issues, again, prior to any sort of commercial marketing or launch of the biosimilar product. At the end of the 12-year period is when the market exclusivity would end. And as you can see on this slide, we have a 1-year period at the end, which contemplates potentially a 1-year period of market exclusivity for the first interchangeable product. And the statute contemplates that the first product determined to be interchangeable is entitled to a 1-year period of market exclusivity of commercial marketing or launch, and also some additional different scenarios of exclusivity depending upon what's happening in the underlying litigation. One other item of significance that we wanted to note is that a product that's determined to be biosimilar and approved by the FDA as biosimilar is not entitled to any period of market exclusivity. To be entitled to market exclusivity, again, there must be showing that the product is determined by the FDA to be interchangeable, and it's only those classes of products that enjoy some period of exclusivity. So with regard to the pre-litigation exchange, the statute contemplates 3 phases of exchanges between the parties before any sort of litigation is initiated. In phase 1 is what we refer to as a disclosure phase, and that is where a biosimilar applicant whose application has been accepted by a review from the FDA would disclose its application to the reference product sponsor. The reference product sponsor would then have an opportunity to identify patents that it believes may be infringed by the biosimilar applicant, and similarly, the applicant has an opportunity to identify patents as well. After that disclosure phase, the parties then go into what we refer to as the contention phase, in which both the reference product sponsor and the biosimilar applicant would exchange information on their infringement and validity positions for the patents that have been identified in the exchange. And then finally, there's a negotiation period in which the parties try to reach agreement as to which patents will actually be litigated in this first wave of litigation. So to illustrate this in a little bit more detail, we've prepared the next slide, which is a timeline of the exchange. As you can see, the top half that's shaded in pink would be the activities that the reference product sponsor would be engaged in, and the bottom half shaded in blue would be the responsibility of the biosimilar applicant. And as you can see, the timeline starts again when the FDA accepts the biosimilar application for review. Within a pretty short period of time, of 20 days, the biosimilar applicant must notify the reference product sponsor of this application and also disclose the application to the reference product sponsor and additionally provide manufacturing process information on its proposed product. At that point, after the disclosure of the application, the timeline switches back up into the pink, into the reference product sponsor, who must then identify patents that it either owns or has exclusively licensed that would potentially be infringed by the biosimilar applicant, and also identify patents that it's potentially prepared to license to the biosimilar applicant. Following that initial exchange, the timeline shifts back to the biosimilar applicant to provide a detailed statement of invalidity and non-infringement with respect to the reference product sponsor patents. There's an opportunity to also list additional patents at that point in time, and the applicant must also respond to any offers to license. Following that, the timeline shifts back up to the reference product sponsor, who then prepares its own patent statement responding to the infringement and invalidity contentions. And then following that, there's a good faith negotiation between the parties on the patents that have been identified, and the statute provides a 15-day period for that negotiation to take place. And once the negotiation has happened, then there are 2 potential scenarios for how litigation may be initiated. And you can see the 2 potential scenarios on the next slide. The top row is if the parties reach agreement on the patents to be litigated, and there's a defined period of time in which the reference product sponsor would then have to bring suit on the listed patents, and then the biosimilar applicant has an obligation to then notify the FDA of that infringement action. If there's no agreement, then there's some additional procedures that need to take place. There's a procedure in which the biosimilar applicant must identify the number of patents that it thinks it should be litigated. The parties then exchange lists of patents, and then the reference product sponsor would have a defined period of time, 30 days, in which to bring suit on the patents on those 2 lists, and the applicant must then notify the FDA. So in addition to this timeline, the statute also contemplates 2 other procedural issues which I wanted to briefly note. One is that if a reference product sponsor obtains newly issued patents or in-licensed patents while this exchange is taking place, the statute does require the reference product sponsor to provide notice to the applicant of these newly issued or newly licensed patents, and then the applicant has a 30-day period of time in which to respond with invalidity and non-infringement contentions. These new patents are not part of any negotiation, but can be included in subsequent litigation. And also, I wanted to note there is also contemplated in the statute a preliminary injunction proceeding, and that is if a biosimilar applicant intends to commercially market or launch a product, it has to provide at least 180 days notice to the reference product sponsor of its intent to market or launch, and the statute then allows the reference product sponsor to bring an action in federal court to request a preliminary injunction on patents that aren't part of the first wave of litigation, but patents that may have been identified in the pre-litigation exchange. And then finally, I wanted to note that there is still some uncertainty and unanswered questions with regard to what is required to demonstrate biosimilarity. The FDA has issued a number of draft guidance in this area, which we've listed on this slide, and additional guidance is expected from the FDA, particularly with regard to what is required to demonstrate interchangeability for a product. So with that overview, I'm going to turn the slides over to Carol, who will be talking about how, as a reference product sponsor, a party would prepare itself for this pre-litigation exchange.
Good morning, everyone, or good afternoon, depending on where you are. So once you've just looked at this pre-litigation exchange, you can see it's rather complicated. And how does the reference product sponsor prepare for this exchange? Obviously, given the tight deadlines, the 60-day periods of time during the pre-litigation exchange, the reference product sponsor is going to want to be prepared ahead of time. And so we wanted to go through a couple points to address things that could be done ahead of time. One of the first and probably the most obvious things would be to look at the portfolio, organize the patents. Perhaps your portfolio is spread among several different firms. You have different people in-house responsible for various aspects of your portfolio. Getting all of that information into one place, well, it seems pretty simple, might be complex just given the large amount of patents that may be a part of your portfolio. The same can be said with respect to the patents that you may have licensed in, reviewing those patents as well as the license agreements, and we'll go through some of the aspects of the license agreements in a minute. The other thing would be to consider licensing or acquiring third-party patents that could be asserted against a potential applicant. Obviously, while you're preparing before you receive the biosimilar application, you're not going to know the details of the particular product at issue, but a lot of companies are at least announcing generally which products they're going after, and so there is some information in the press at least as to which products are currently targets of biosimilar applications or development work. And so utilizing that information to at least gather all of your information together will help during this exchange. Another issue to consider just logistically is who is going to have access to the biosimilar application. Under the statute, the access to the application is limited to outside counsel as well as one in-house counsel. The application has to remain confidential, and importantly, there is a prosecution bar specified in the statute. So counsel that will have access to the biosimilar application will not be able to be involved in prosecution relevant or related to the reference product. And obviously, those people involved in the litigation or in the prosecution are those most likely to have the most knowledge about the patents in your portfolio. So identifying someone in-house who can be the point person, maybe the team of people, as well as outside counsel in advance of the pre-litigation exchange will be important in getting them up to speed. Oftentimes this technology is very complicated. There is a large amount of patents covering various aspects of the product, and having people available ahead of time that understand the technology and the portfolio is going to be very important, especially given the short time frame. of the pre-litigation exchange. During the exchange, the reference product sponsor is also required to identify patents that may be appropriate to license to an applicant. So considering some of those issues ahead of time, if there are any patents that you would potentially want to license, figuring that out ahead of time would be helpful. Another important point is to look at the patent portfolio that you have and evaluate the risk associated with identifying patents during the patent exchange. Looking not only to potential infringement considerations, but also looking at validity concerns, also looking at what these patents are applicable to. It may be that you have a series of patents that cover more than just one product in your product line, and perhaps you don't want to risk those patents in an initial litigation under the BPCIA. And a couple things just to note, that there are some penalties in the statute for not complying with the pre-litigation exchange. Importantly, if you do not list patents in the initial exchange, then unlisted patents can't be used for the preliminary injunction proceedings that Sheila had mentioned that would occur upon notice of marketing from the biosimilar applicant. Another penalty is that if the reference product sponsor fails to timely file suit, which you have a 30-day window roughly to file suit, then the reference product sponsor is limited to a reasonable royalty only. So clearly you would not want to miss that deadline of filing suit. So being prepared ahead of time will be really important. So now we'd like to turn to a couple of issues that come up in the context of license agreements. Oftentimes, with respect to these types of products, you've in-licensed technology, perhaps you've even licensed it to other people. A lot of these license agreements were put into effect before the BPCIA was enacted, or perhaps the BPCIA was not considered when you entered into various license agreements. So we just wanted to run through a few things that could be considered going forward and perhaps even renegotiated in existing licenses. For example, timing. Given the provisions requiring prompt action during the pre-litigation exchange, you may want to put into agreements that the licensor and licensee will cooperate and be able to address the pre-litigation deadlines. Notification terms within the license agreement should also be reviewed. You may want to, especially if you're the licensor, you may want to make sure that you are notified of the filing of a biosimilar application. You might want to also include notice procedures tied to the various deadlines in the patent exchange. Another thing to consider is that oftentimes license agreements contain provisions that require a party to notify the licensor when they are aware of potential infringement of the patents. And given that during the pre-litigation exchange, you're under a confidentiality requirement, and during the litigation you most likely will have a protective order. Are those consistent with the notice provisions you have in your license? Just something to look at. Another thing to consider is, do you have the ability to sublicense as the reference product sponsor licensee? This will come up not only in the context of the initial offer to license patents, but it could also be an issue in potential settlement agreements. You may need to have the right to sublicense to effectively negotiate a settlement. Another issue to consider is just standing and joinder. If you're looking at your license agreement, do you have standing on your own as the RPS to assert a patent that you've exclusively licensed, or will you need to join the patent owner? If so, considering those issues ahead of time and getting agreement will be helpful. as we mentioned earlier, there are confidentiality and access restrictions in the BPCIA. With respect to a patent owner or licensor who has exclusively licensed their patent to the RPS, but has also maintained a right to be involved in the litigation, the BPCIA does contemplate that that third-party patent owner could have access to the biosimilar application. However, they do have to agree to the prosecution bar that is in the statute. Another thing to consider is control of the litigation and the patent exchange. Who is going to have control of that? Who is going to make strategic decisions? Are there certain people that need to be involved? Just figuring out the logistics ahead of time will be quite helpful. You want to figure out who's going to choose counsel, importantly, who's going to pay. Those are all things you'd want to look at ahead of time and not be trying to decide during the tight deadlines of the pre-litigation exchange. And finally, the reference product sponsor should also, when they're reviewing their patent portfolio, look to the portfolio as a whole and figure out if there are holes in the portfolio. Are there design arounds or alternative manufacturing processes that could be covered? Mine the existing applications for additional claims. Another thing to consider is the potential use of the new AIA procedures to strengthen your portfolio. And for a more detailed discussion of those procedures, I'm going to turn this over to Eli.
Thanks, Carol. Okay, so following the final round of implementation of the AIA, we have a new set of options to consider here to strengthen your portfolio, and a new set of options to consider when doing something as simple as filing continuations. Of course, ex parte re-exam and reissue options are still available, but we suspect they'll be at least partially replaced by this new supplemental examination option. And there are new items to think about in regard to IPR and PGR procedures when filing continuations. Of course, you can always have a new standalone filing, and as you're probably all aware by now, interferences are still around, but they'll be slowly phased out in favor of derivations as we go forward. So what is supplemental examination? Well, this is basically a submission by the patentee to the Patent Office, providing the Patent Office with any information that they believe to be relevant to the patent. So this allows them to bring up any ground of patentability that they want re-examined by the Patent Office. So 101 to 112, they can have the PTO look at it and bless it again. If the PTO thinks this material is relevant, they'll start with basically a glorified ex parte re-exam proceeding. If the PTO doesn't think that it's relevant, they grant you a certificate and you go forth with everything being considered. One of the big benefits of this proceeding is any of the items that are considered can know at that point can't be used against you for inequitable conduct down the line. That's assuming everything's timely filed. One item to keep in mind is that there are limits on the number of items that you can submit in each supplemental examination request. It's 12 items. It's somewhat vaguely defined, and so if you've got a 12-way obviousness proposed rejection, then that's all 12. But if you're submitting a statement regarding 101 or 112, that may or may not be a single item. To some extent, that's just a cost aspect because you can file numerous supplemental examinations at the same time. This is something that's available to all enforceable patents at present. The cost is fairly steep. It's $16,500, but the bulk of that is for the re-exam proceeding. And if there is no instituted re-exam proceeding, then you get that money back. So you're really looking at something closer to $4,500. The standards that PTO will be looking at when they analyze your request is whether or not there's a substantial new question of patentability, and that's basically, is there a substantial likelihood that a reasonable examiner will think that this is important for patentability. This is supposed to be at least the first phase of this process, where the PTO reviews your submission and decides whether or not there is a question, should happen within 3 months of the filing. And so that should be concluded relatively rapidly. Now, if you go into the re-exam process and you don't get that certificate that everything's clear right at the first 3-month period, then you're going to go through some extended re-exam proceeding following that. Continuations, definitely a traditional way of boosting or strengthening your portfolio, but with the option of IPR and PGR that the other side will have, you'll want to think about the patentee estoppel aspects that could come back to haunt you. And so basically in these IPR or PGR proceedings, if you have to cancel a claim and if there's a final written decision following that, the patentee is stopped from pursuing that claim in any other proceeding or a claim that's not patently distinct from that claim. And so one option to minimize that aspect is file a number of continuations at the start of the process. As soon as you get dragged into IPR, file them with prioritized examination so they go through quickly. And if these are fairly focused claim sets with sequences or something like that, you could probably get them issued within 6 or 7 months. And by issuing before, you don't have to worry about the estoppel effect. Also, another way of minimizing the impact of IPR and PGR that will be going on at the same time is to have a couple of patents and file them in continuations as very focused claim sets, single claims, clearly valid, so that it's more difficult to drag them into the IPR and PGR proceedings, and it's a bit safer from all the other complexity that's going to be happening. Finally, it's something that's especially relevant now for filings that have happened in the last year and going forward. You have an opportunity to set up a priority chain so that you can have a set of continuations that are entitled to priority to the pre-AIA statutory scheme and a set that's entitled to the AIA or even hybrids of the two. Keep that in mind as an option because there may be scenarios where one will be better for you than the other. And of course, you won't know that for quite some time. So we have a number of opportunities here for this, employing new AIA tools here. One other item, I guess, that comes up as an opportunity for kind of adjusting the timing of your continuations is to file a series of applications at the start of the process and file some with or without prioritized examination, and you'll have more control over when those cases actually issue. And so you can pick and choose to some extent, especially if you're pursuing focus claims, how much those claims will be part of the rest of the biosimilar process, when they'll have to be disclosed, and how much other information you'll have before those claims are granted. Again, supplemental exam, a number of advantages. The other item to keep in mind here is that for these PGR, IPR, and derivation proceedings, there's an easy out for a number of those items, and that's some sort of settlement negotiation. And when that comes up, you don't want to limit yourself to your portfolio or this particular product even. Think outside of the box, look for something else that you can leverage against the other side, whether it be other IP or something completely unrelated. And with that, I'll turn it back over to Sheila for the applicant's perspective.
So we'll switch gears a little bit and now talk about, as a biosimilar applicant, what are some of the things that you can do to prepare in advance for the patent exchange. And just as Carol mentioned, that the RPS can work in advance to organize their portfolio and identify potential products to be asserted against biosimilar applicants. As an applicant that's developing a product, it's important to proactively identify patents from the reference product sponsor that could be potentially asserted in the pre-litigation exchange. And these patents, again, would include not only patents that are owned by the RPS, which can usually be found by doing searches in the patent office for patents owned or assigned to the reference product sponsor, but it also would include patents that are exclusively licensed by the reference product sponsor, which may be a little bit harder to find. So it's important to be thinking about both of those categories of patents in terms of identifying what might potentially be at issue. Another thing to be thinking about is any pending applications that may issue during the exchange, and as Eli mentioned, there are strategies for the reference product sponsor to accelerate that process. And it's important to be monitoring the portfolio as well, to see what claims are issued or being allowed, and starting to think about what your defenses may be to those patents. Another thing, again, which is sort of our theme for this webinar, is that because of the expedited procedures of the exchange, an applicant only has 60 days from the date that it's notified by the RPS of potential patents to provide a patent statement regarding non-infringement and invalidity. It's important to be thinking about that early and developing those defenses well in advance of actually entering the exchange. For non-infringement and for invalidity, this might require testing or expert analysis, depending on what claims would be asserted. So it's important to line up experts and start to figure out what tests you might need to be doing to demonstrate your non-infringement or invalidity positions. Another thing to think about in view of recent case law is whether the safe harbor exception to patent infringement may be available to the biosimilar applicant for any of this activity that could be tied to regulatory submissions to the FDA. So those are some of the things from the biosimilar applicant to think about in preparing for the exchange. Another aspect of this also is what AIA procedures can an applicant take advantage of to use during the pre-litigation exchange, and so Eli will be addressing those as well.
Thanks. So now that you've done the research to figure out why these patents are invalid, what can you do with that information? Well, one of the options is, of course, all these post-grant proceedings. And one item before we go off into the post-grant world to think about, or just keep in the back of your mind, is that you can also participate to some extent in the application process, right? We have this third-party submission, expanded third-party submission option now. There are certain aspects or situations where a protest under 291 will be available. So you can participate in the pending application to some extent. But we're going to focus here on what you can do with issued patents. And of course, you still have ex parte re-exam. We now have inter partes review. We'll start having post-grant review, and of course, interference shifting over to derivations. Which option you choose will really depend on of course, the specific facts. And there are a wide range of benefits and risks for each of these options. Everything from something as basic as what's the cheapest option, how much control do I need, how fast do I need this to be concluded, do I want the other side to be able to make amendments, do I need discovery to establish anything, do I want estoppel, or do I want to be anonymous? We'll go into those in some detail. So just starting with ex parte re-exam as kind of the baseline, this is traditionally thought of as the least expensive option for challenging an issued patent. It's also thought of as having a relatively low success rate. In part, that's because 12% of the petitions that's basically the success rate for resulting in the patent being unpatentable. That said, 65% of the petitions result in some sort of claim amendment. So it may be that for your particular scenario, you're more interested in a claim amendment than a complete finding of unpatentability. So that may be all the success you need. At the end of the day, though, there's still a full quarter of the cases that are petitioned that result in no change in the scope of the patent. The real aspect here, or point of comparison with the other options, is that there's no further involvement by the third party in the re-exam proceeding. As far as speed is concerned, there's no formal requirement. Generally, it takes about 2.5 years. It varies to some extent. If there's litigation that is ongoing, then that'll be compressed down to a year. That said, at the end of that, the patent owner can still appeal to the PTAB, and that's going to drag on another year or two. And so you've got that added time as well. There's no real discovery available here. There's no estoppel, and there's no settlement option for ex parte re-exam. In contrast, IPR and PGR allows for a lot more third-party control, and because of that, there's going to be significantly higher costs. It's generally considered that this will be a faster option, although we'll see exactly how that plays out in all the possible scenarios. It is supposed to be limited to no more than 18 months from the petition date to the final written decision, but that is extendable for 6 months for good cause. Unlike a re-exam, the patent owner can't appeal to the PTAB, but they can request a rehearing within 30 days, but presumably that will go much faster than a a formal appeal will. As far as the success rate is concerned, as this has just started up, we're still going through these. None of the IPRs have resulted in a final decision yet, final written decision, and of course we don't have any PGRs yet either. That said, more than 90% of the petitions so far have led to an initiation of trial, and usually those that have failed, there's a kind of clear reason why they failed. And of course, the challenger here is an active participant throughout the whole process. There will be some limited discovery here, but it's going to be very focused, so don't expect that you can go on any sort of fishing trip to supplement anything else. Whatever else you can find from the rest of the process around you might be useful here, but it's going to be focused. Estoppel is one of the more interesting aspects for IPR and PGR. There is the petitioner estoppel, which is on a claim-by-claim basis for any issue that was raised or reasonably could have been raised. There's also a patentee estoppel, which I mentioned earlier, and that's basically going to stop the patentee from pursuing any claim that they canceled or a claim that's not or a claim that's patently indistinct. One item to keep in mind, though, is that estoppel doesn't apply unless there's a final written decision, and so if the parties settle, you can avoid estoppel on both sides. So here's a representative timeline. I'm not going to go over this in detail, but one thing to note, though, is that the first 6 months is kind of the petition decision phase where the board's deciding whether or not to institute the proceeding. In that phase, it's kind of split in 3 months and 3 months to give the board 3 months to make the decision, but the patent owner has the option of replying to the petition itself. If they don't reply, then they can compress that time down quite a bit if they want to. Similarly, in that 12-month period, the first response is by the patent owner. If they don't amend, then the opportunities for the other side to comment are reduced as well. So the patent owner has a decent amount of control over its timing. Now, we don't expect that in a normal situation the patent owner would want to accelerate these things, but in a scenario where the patent owner has already done a lot of diligence and already knows all of your arguments, then maybe they'll play with this timing a little bit. So here's just a comparison between re-exam and IPR and PGR. I'm not going to go through all the differences. I just want to note that while they're both at the USPTO, re-exam is going to be in front of 3 examiners and all the associated bureaucracy, right? So if you've got an applicant, a patent owner that files a declaration and the examiner doesn't like it, they can still go to a QUAS, and the QUAS will help you along as the patent owner to get that through. In contrast, IPR and PGR is going to be with 3 patent attorney judges. They probably, really don't care that there's a QUAS, much less what the QUAS has to say about a declaration. So different items depending on what your scenario might be there. Also keep in mind that re-exams can be anonymous, whereas IPR and PGR will not be. Other differences between re-exam, IPR, and PGR. Re-exam is available for any patent, same with IPR. In contrast, PGRs, we won't see those for a while because they're first to invent only. Timing requirements, re-exam can be filed at any point. IPR can be filed at any 9 months for those patents that are PGR relevant or immediately after grant if they're not PGR relevant. If you've been served with a complaint for a lawsuit, you've got a 1-year window that starts at that point for filing the IPR. And of course, the petitioner, you can't file a DJ of invalidity, then turn around and file an IPR or a PGR. So keep that in mind. Also, the grounds for requesting review are going to be different for each of the cases. 102 and 103 are actually available for all 3 of the options. In contrast, obviousness type double patenting is available for re-exam, but it's not available for IPR, at least under the vast majority of the interpretations, available for IPR or for PGR now. That said, there is a proposal to drop obviousness type double patenting into the statutory scheme, and if that happens, then maybe it'll be relevant under 282 and for PGR. PGR will allow you to attack any other ground apart from obviousness type double patenting. So 101 to 112, all available for PGR. again, estoppel will apply for IPR and PGR for those items that you could have raised. No estoppel for re-exam. And then the barrier to overcome to initiate the proceeding is different for each of the items as well. For re-exam, you've got a substantial new question of patentability, so relatively low. For IPR, it's a reasonable likelihood that the challenger will prevail on at least one claim. And the PTO is saying right now that's basically at least 50-50. And for PGR, the analysis is more likely than not that a claim is invalid, and so the PTO is saying that's greater than 50%, or a novel unsettled legal question. So you could look at this as an increasing in difficulty as you progress from left to right, but that's not always the case. For instance, for re-exam, if that question of patentability is an old, previously addressed question of patentability, it doesn't matter how convincing it is, you're not going to get into re-exam with that, but you might get into IPR or PGR with that. Final comparison between the district court and IPR or PGR. You want to ask yourself, how much technical training do you want the reviewer to have? If you want them to have a lot of training, then IPR and PGR will put you in front of 3 patent attorney judges. If not, district court will put you in front of a judge and jury. Of course, if you need discovery and evidence, you're really not going to get that for IPR and PGR, at least not to any real extent. And so district court will weigh in favor there. And then as far as the actual invalidity standard that you're looking at and claim construction, IPR and PGR will be the clear winner there, as you only have to show it by a preponderance, and the claim interpretation will be broadest reasonable. So more favorable for most scenarios, especially those where you're using prior art. Finally, ask yourself whether or not you want the other side to be able to make amendments. Maybe you do, maybe you don't. That won't happen in district court, of course, but PGR and IPR it will be available. So we have plenty of opportunities here to use these proceedings. There are going to be some situations where there's just a clear winner for which proceeding to go with, right? So let's say you're really early on in the process. You don't want to let anybody else know you're even in this space. You've got plenty of time to let a full examination play out, and maybe your only real issue is obviousness type double patenting. Ex parte re-exam is, the type of process that you'll, or procedure that you'll use. You also want to ask yourself, what is your goal here? Are you trying to completely invalidate the whole patent, or do you just want to carve something out? Do you want a lot of those claims to stay around, perhaps to block out other competitors? And if that's the case, then IPR and PGR will be a tool that will allow both parties to come to some agreement and understanding and adjust the claims accordingly. Also keep in mind, of course, you have this new option of patentee estoppel, and of course that's going to be more effective the earlier on in the process that you can do it, so that, again, they can't file these other continuations to have these basically issued claims that are insulated from the estoppel effect. Also, consider whether or not you want a lot of this information to be public. It will be submitted to the Patent Office. You can request for certain things to be sealed. That said, it's pretty clear from the PTO comments that they don't want to seal the entire record. So consider whether or not you file or you share with the other side first to see what you can negotiate with. And then finally, even though IPR and PGR have estoppel issues, there are ways of minimizing it. And it's not just settlement. There are timing scenarios as well that you can play with to minimize things. And with that said, I think this is back over to Carol for enforcement considerations.
So looking at this from the reference product sponsor, what we wanted to do is we presented obviously a lot of information here, and so we wanted to just summarize a few of the things and just raise a couple additional points. With respect to the reference product sponsor, as we mentioned, considering the strength of all the patents in the portfolio will be important in the pre-litigation exchange, and then once you've seen the biosimilar application, obviously, determining strength of your infringement case. Perhaps there are patents that are better suited to this particular application. Perhaps you know of other applications that are coming down the line that maybe there's a patent that's more applicable in the later case. Looking at the timing of the litigation, as Sheila mentioned, there are several waves of litigation contemplated by the BPCIA. There's obviously your first wave that is initiated at the conclusion of the pre-litigation exchange. There's also the potential for the preliminary injunction proceeding upon notice of marketing by the biosimilar applicant. And then potentially there's a third wave of litigation once the biosimilar applicant has already launched their product. You could envision additional patent litigation at that point. And so looking at the various patents that you have and trying to figure out when you want to implement patents in the various ways. As we mentioned earlier, considering the use of platform technology or research tool patents, you need to decide when you want to, or if you want to, involve those patents in the litigation. Also, if you want to save some of those for future biosimilar applicants. We talked about claim strategies and preliminary injunctions. Another thing to mention that we touched on was the role of the third-party patent owner or licensor. Obviously, under the pre-litigation exchange, there are some limitations on their involvement with respect to access to the biosimilar application. Once you are in litigation, most of that access will be determined by the protective order in the case, and those are often highly negotiated documents. And so figuring out how involved those people need to be in the litigation itself can be dealt with in terms of the protective order. So I'm going to turn this over up to Sheila to look at this from the applicant's point of view.
So in terms of enforcement considerations on the side of the biosimilar applicant, one of the biggest decisions is to decide whether you want to take advantage of this abbreviated approval pathway with its disclosure and exchange requirements, or perhaps just file a regular biologics license application and avoid the pathway completely. So that's kind of an initial decision for the applicant to make and consider what sort of data, clinical data and others required to proceed on the two different pathways. Another strategic consideration is at what point after the 4-year data exclusivity period you want to actually submit your application for review for the FDA. There's theoretically an 8-year window, so it may be advantageous to submit it early to try to resolve the patent issues early in the 8-year period, or perhaps if there's other competitors on the market, and maybe there's a reason to wait a little bit and see what develops in terms of challenges to the patent. Post-grant challenges is something we've already discussed, but deciding whether and when to pursue those in view of the timeline is another thing for applicants to consider. And as Carol mentioned, there could be other competitors, so it's important as an applicant to be thinking about who else might be out there, what sort of patent challenges are they pursuing, is there a way to position yourself to get a strategic advantage over those other biosimilar applicants with regard to your own non-infringement or invalidity positions. Again, the third wave of litigation, so as Carol mentioned, at the time a biosimilar applicant actually launches product, there's a potential for another patent infringement suit, not only by the reference product sponsor, but potentially by any third party that has a claim of infringement. So it's important to be thinking about that and preparing for that as well. And then finally, as a biosimilar applicant, there would be reasons to develop your own patent portfolio to potentially use for cross-licensing with a reference product sponsor for potential use against other future biosimilar applicants. So those are some things to be thinking about from the biosimilar applicant's perspective. I think we have a few more minutes and possibly some time for questions. So I just wanted to note a few things. We do have some additional resources available. The slides, if you're interested, we can send them to you. Just send us an email. We'd be happy to send that to you. Carol and I have written an article on patent licensing considerations in view of the statute. That's also available if anyone is interested in a copy. And then we've also put together a more detailed appendix that goes through the statute and identifies the specific requirements of the pre-litigation exchange, which again, we would be happy to send to you. So with that, I think we have at least a few minutes for questions from the audience.
Thanks very much. So we actually have a note from a participant and then a number of questions. So the note was, as Sheila, you were talking, commented that I would note that the first interchangeable biological product is granted exclusivity only to other interchangeable biological approvals, since biosimilars are able to be approved before and concurrent to the first interchangeable biological approval. And so we just wanted us to note when the first interchangeable product is granted exclusivity only to other interchangeable approvals.
Can I interject just for a second? One thing that's important to note about interchangeable versus biosimilar, in addition to the exclusivity aspect, is that if you are designated as interchangeable, then at the pharmacy, the pharmacist can substitute the interchangeable product for the reference product sponsor. Currently, although there is a movement in the various states to somewhat limit that, and so it'll be kind of a moving target to see how that works out, but there is an advantage other than just the exclusivity for having that interchangeable notation.
Okay. And then one question for Sheila. It seems like a biosimilar applicant has to disclose a lot of confidential information to the reference product sponsor during the patent exchange. Is this confidential information protected in any way?
Well, that's a great question, and so there is a lot of concern among biosimilar applicants that this exchange under the statute contemplates that, again, the entire application has to be disclosed to the reference product sponsor, and so there are in the statute some protections built in, and I think as Carol mentioned, there's restrictions on who can actually view the biosimilar applicant's application on the reference product sponsor side, specifically outside counsel, as well as one designated in-house counsel from the reference product sponsor are allowed to see the biosimilar application, and those counsel cannot be engaged either formally or informally in any kind of prosecution that's relevant or related to the reference product. So there's that kind of protection built in, and there's also the opportunity for the parties to negotiate a protective order or other sort of agreement to further protect the confidentiality of the information. And the statute also gives the biosimilar applicants the right to bring a declaratory judgment action if they believe that there's been a breach of any of the confidentiality provisions of the statute.
Okay, thank you. And I wanted to clarify that all the materials we're talking about are going to be posted on our website. We'll send you links to that in an email, and so you don't have to individually email us to get that information. We'll have that up on our website after the webinar is concluded. And so I have a question for Eli. Do we know how the various post-grant options will interact with one another when more than one of these options is pending at the same time?
Yeah, so not explicitly. Some of these things are laid out, but not many. What is clear is the board is going to have a lot of control, a lot of discretion, and be able to stay, terminate, combine, whatever they really want to do, they'll be able to do. They have so far been very willing to stay re-exam proceedings, and there are definitely scenarios that you could envision, say, with PGR and a reissue proceeding, something where they would be caught in a catch-22 at the end if, for instance, the reissue went through before the PGR concluded. They definitely step in and stay. And I guess the other factor to keep in mind here is the one-year time period for some of these proceedings. And so they're going to want to stay within that one-year time period, and they'll use those other tools to make sure that they can.
Okay, and I think we've got time for one more question. We're fortunate that we had a lot of participants today and a lot of questions, so we thank you very much to the participants for joining us. So one more for Carol, which is the pre-litigation exchange is very comprehensive. Are there any other issues that the reference product sponsor should be considering in preparing for the patent exchange?
Yes, there are a couple other considerations, and some of these just go back to your basic pre-litigation investigations. The reference product sponsor is going to want to look at the various venues throughout the U.S., and most likely there will be the possibility of filing the lawsuit in more than one venue. The BPCIA did not specify a particular venue, so looking at those considerations ahead of time will be important, because you do have just that 30-day window once you've decided to file suit to go ahead and bring that lawsuit. The other thing to think of with respect to standing is oftentimes you may have acquired some of the patents that are in your portfolio, and looking at the chain of title and ownership issues, making sure you've perfected all of those titles and making sure your ownership is clear such that you don't have to deal with any standing challenges. Those are a few additional considerations.
Great, thank you very much. I think, unfortunately, we are out of time, and so I, again, wanted to thank all the participants for joining us today. Again, we'll have this information sent out to you and available on our website for any colleagues that missed the webinar today, and we look forward to your comments and hopefully have you join us for future webinars from Kenobi Martins. Thanks again, and have a great day.